Number 1. Antoinette Frank, the officer who murdered her own. There are criminal cases that shock a city and cases that permanently alter its identity. And then there are cases so grotesque, so fundamentally incomprehensible in their betrayal of every value law enforcement claims to uphold, that they leave a wound in a community that never fully heals. The case of New Orleans Police Department officer Antoinette Frank is one of the latter. It is a case that, nearly 3 decades after the night it unfolded, remains one of the most disturbing and widely studied examples of police criminality in the history of American law enforcement, not simply because of the violence involved, but because of the calculated, premeditated, intimate nature of what Frank did on the night of March 4, 1995, and because of the terrifying ease with which she almost walked away from it entirely. Antoinette Frank was born in 1971 in Louisiana, and her early life was marked by instability, dysfunction, and the kind of psychological turbulence that would later become the subject of intense forensic scrutiny. She had a difficult childhood by most accounts, raised in circumstances that offered little in the way of stability or consistent parenting. Her father, Adam Frank, was a troubled man with his own history of legal and personal difficulties, and the household in which she grew up was not one that cultivated the sort of moral clarity and emotional stability one might hope to see in a future law enforcement officer. That she ultimately joined the New Orleans Police Department at all is, in retrospect, a profound institutional failure, one that would be examined in excruciating detail after the events of that March night. When Frank applied to the NOPD, she raised red flags almost immediately during the psychological screening process. The department's own psychological evaluator recommended against hiring her, noting concerns about her mental fitness for the demanding and emotionally charged work of policing. That recommendation was overridden. Frank was hired anyway, and in doing so, the New Orleans Police Department placed a psychologically compromised individual into one of the most powerful roles in civil society, handing her a badge, a weapon, and the full authority of the law. It is a decision that would cost 3 people their lives. Frank was assigned to the 7th District of New Orleans, a high-crime area that demanded experienced, emotionally grounded officers. She was partnered with Officer Ronald Williams, Jr., a young man by all accounts devoted to his work and to his community. Williams was working an additional security shift at a Vietnamese restaurant called Kim On's on Versailles Boulevard, a common arrangement for New Orleans officers who supplemented their income through private security work at local businesses. Frank had worked at the same restaurant in a similar capacity and had developed a familiarity with the owners, the Vu family, who ran the establishment with the dedication and pride typical of immigrant entrepreneurs who had built something from nothing in their adopted country. The Vu family trusted Frank. They knew her as a police officer, as someone who had stood in their restaurant in uniform and represented the law. That trust would prove catastrophically misplaced. On the night of March 4, 1995, Antoinette Frank arrived at Kim On's restaurant not in the capacity of a protector but as a killer. She brought with her a young man named Rogers Lacaze, a teenager with a criminal history whom Frank had inexplicably allowed into her life and who would serve as her accomplice in what was about to unfold. The restaurant was open late, as it often was, and Officer Ronald Williams, Jr. was on duty there, providing security. What happened next was methodical, deliberate, and savage. Frank and Lacaze entered the restaurant. Frank, who knew the layout, who knew the staff, who knew Ronald Williams personally, shot her fellow officer at close range. The sound of gunfire sent the Vu family into a panic. Ha Vu and her brother Quang Vu, 2 of the family's children who were working that night, were shot and killed. A third sibling, Chow Vu, survived only because she had the presence of mind to hide inside a walk-in cooler and remain completely still and silent while Frank and Lacaze ransacked the restaurant and stole cash from the register. Chow Vu lay hidden in that cooler, listening to the sounds of the robbery and the aftermath of her siblings' murders. And in doing so, she preserved the crucial eyewitness testimony that would eventually bring Antoinette Frank to justice. In the immediate aftermath of the murders, Frank did something that reveals the depth of her audacity and the utter contempt with which she regarded the institution she served. She called the crime in to the police department. She responded to the scene as an officer. She stood among her colleagues as they investigated the murders of 3 people, 2 of whom she had just killed, and performed the role of a grieving, concerned fellow officer. She spoke to detectives. She moved through the crime scene, She participated in the early stages of an investigation into crimes she had personally committed. It was a brazen performance that might have succeeded were it not for the survivor hiding in the cooler. When investigators spoke with Chow Vu, who emerged shaken and traumatized from her hiding place, the truth began to unravel with devastating speed. Chow identified Frank as one of the shooters. She had seen her. She knew her. The woman who had stood in their restaurant as a symbol of safety and protection had come back that night to murder her family. Frank was arrested and charged with 3 counts of first-degree murder. The trial that followed was one of the most closely watched in Louisiana history. The prosecution presented a case built on Chow Vu's eyewitness testimony, ballistic evidence, and the testimony of Rogers Lacaze, whose own legal proceedings ran parallel to Frank's. The defense attempted to challenge the reliability of the eyewitness identification and to raise doubts about the forensic evidence. But the weight of the evidence against Frank was overwhelming. She was convicted on all 3 counts of first-degree murder. The jury recommended the death penalty, and Antoinette Frank was sentenced to die by lethal injection. As of the time of this writing, Frank remains on death row at the Louisiana Correctional Institute for Women, having exhausted numerous appeals over the decades. Her case has been studied extensively in law enforcement training contexts as an example of institutional failure in the hiring and screening process, of what happens when psychological red flags are dismissed or ignored in the interest of filling a roster. The NOP's decision to override its own psychological evaluator's recommendation and hire Frank anyway represents one of the most consequential institutional failures in the department's history. The 3 lives taken that night, Ronald Williams Jr., Ha Vu, and Quang Vu, deserved better. The Vu family, who had built their restaurant through years of hard work and who had trusted the police officer who walked through their door, deserved better. And the people of New Orleans, whose faith in the NOPD was already strained by an era of widespread corruption within the department, deserved better. The case of Antoinette Frank remains a defining cautionary tale about what happens when the systems designed to prevent dangerous individuals from obtaining the badge are compromised, ignored, or simply insufficient to the task of identifying the evil that can hide behind the most ordinary of faces. Number 2. Amber Guyger, the officer who turned a neighbor's home into a crime scene. There are moments in the history of American criminal justice that crystallize, with painful clarity, the complex intersection of race, law enforcement culture, and the deadly consequences of a badge that carries with it a presumption of authority even in the most obviously unjustifiable circumstances. The case of former Dallas Police Department officer Amber Guyger is one of those moments. It is a case that provoked national outrage, sparked intense legal debate about the boundaries of police authority, and produced a trial outcome that left millions of Americans simultaneously relieved that a conviction had been secured and profoundly troubled by the brevity of the sentence that followed. On the evening of September 6, 2018, Botham Jean was at home. He was 26 years old, a native of St. Lucia who had moved to Dallas to pursue his career as an accountant at PricewaterhouseCoopers. By every account offered by those who knew him, Botham Jean was a man of warmth, faith, and ambition. Someone who sang in his church choir, who was devoted to his family, and who had built a life in Dallas that reflected his considerable talents and his genuine decency as a human being. On that September evening, he was in his apartment, reportedly eating ice cream and watching television, doing what any young professional does on an evening at home. He had no reason to believe he was in danger. He was in his own home. Amber Guyger, then 26 years old herself and a 4-year veteran of the Dallas Police Department, had just finished a long shift and was returning to her apartment in the South Side Flats complex, the same complex where Botham Jean lived. The two had never met, but they lived in the same building, with Guyger's apartment on the 3rd floor directly below Jean's 4th floor apartment. What happened next has been the subject of enormous legal scrutiny, public debate, and ongoing controversy. According to Guyger's account, she was exhausted and distracted, still texting with a fellow officer with whom she was involved romantically, and she parked on the wrong floor of the building's garage. She then walked to what she believed was her apartment, inserted her key, and entered. The door, she said, was slightly ajar or unlocked in a way that seemed normal to her. When she stepped inside, she saw a large figure in the darkness, believed she was in her own apartment and that a stranger had broken in, drew her service weapon, and fired twice. Botham Jean was struck and killed. He died in his own apartment, on his own couch, in the home he had every right to occupy in safety and peace. What makes the Guyger case so profoundly disturbing is not only the act itself, as incomprehensible and tragic as it was, but the constellation of questions it raised about police training, racial dynamics, and the way the legal system responds when an officer kills in circumstances that would result in immediate arrest and prosecution for any ordinary citizen. Guyger had made a significant, fatal error. She was on the wrong floor. She was outside the wrong apartment. The door she opened was not her door. And yet the question of whether she genuinely believed she was acting in self-defense in her own home, or whether her training and her badge created a cognitive framework in which she defaulted to lethal force when a more cautious assessment of her surroundings might have revealed the truth, became the central legal battleground of the case. Guyger was initially arrested and charged with manslaughter before the charge was upgraded to murder. The Dallas County District Attorney's Office brought the case to trial in September 2019, exactly 1 year after the killing. The trial was nationally televised and drew intense public interest. Prosecutors argued that Guyger had made a series of errors that night, that she had failed to observe obvious visual cues that she was on the wrong floor, that she had failed to properly assess the situation before resorting to deadly force, and that her actions constituted murder under Texas law. The defense argued that Guyger had genuinely believed she was acting lawfully in defense of her home, invoking what is colloquially known as the Castle Doctrine, the legal principle that a person has the right to use lethal force against an intruder in their own home. The defense's argument required the jury to accept that Guyger's mistake was genuine and that the law should shield her from murder liability because of that mistake. The prosecution countered that a reasonable person exercising ordinary care would have recognized they were in the wrong apartment before firing. After deliberating, the jury found Amber Guyger guilty of murder. The verdict was met with an outpouring of emotion in the courthouse and across the country. The sentencing phase produced one of the most extraordinary moments in recent American legal history, when Botham Jean's younger brother, Brant Jean, addressed Guyger directly from the witness stand, told her he forgave her, and asked the judge if he could hug her. The judge allowed it, and the image of Brant Jean embracing the woman who had killed his brother became one of the most widely shared and debated photographs of the year, a moment that some interpreted as a profound demonstration of Christian grace and others viewed as emblematic of the impossible emotional burdens placed on Black victims of police violence. The judge herself, Tammy Kemp, later descended from the bench, gave Guyger a Bible and embraced her as well, a moment that generated its own significant controversy regarding judicial impartiality and the different standards to which Black defendants and white officers are held in American courtrooms. Guyger was sentenced to 10 years in prison. Prosecutors had sought a significantly longer sentence, arguing that the gravity of the crime demanded it. The sentence sparked immediate and intense debate, with many civil rights advocates and legal observers arguing that it was woefully inadequate given the circumstances of the killing. Guyger was eligible for parole after serving half her sentence. In 2022, the Texas Board of Pardons and Paroles initially denied her parole application. She was ultimately released on parole in 2023 after serving approximately 5 years. The Botham Jean case remains one of the most consequential police killing prosecutions of the modern era, both for the conviction it produced and for the profound questions it raised about whether the justice system can ever truly deliver equal accountability when the perpetrator carries a badge. Number 3, Stephanie Lazarus, the detective who got away with murder for 23 years. Among the most chilling categories of police criminality is the case in which an officer does not simply commit a violent act in the heat of a moment or under the pressure of a shift, but coldly, deliberately plans and executes a murder, and then uses their position within law enforcement to evade detection for decades. The case of former Los Angeles Police Department Detective Stephanie Lazarus is one of the most remarkable and disturbing examples of this phenomenon in American criminal history. A case in which a sworn officer of the law killed a woman in what investigators later characterized as a crime of jealousy and obsession, and then spent 23 years walking the halls of the LAPD, rising through the ranks, earning promotions, and building a career as a detective, all while the unsolved murder of Sherry Rasmussen haunted the cold case files just a few floors away from where Lazarus worked. The story begins in the early 1980s, when Stephanie Lazarus and a man named John Rutan were romantically involved while attending UCLA together. Their relationship ended, but Lazarus reportedly struggled to let go. By the mid-1980s, Rutten had moved on and fallen deeply in love with a woman named Sherry Rasmussen, a registered nurse who worked as the director of nursing at a medical center in the San Fernando Valley. Sherry was by all accounts an exceptional person. Intelligent, accomplished, warm, and deeply loved by her family. She and Rutten became engaged, and in November 1985 they were married. Almost immediately, Sherry began expressing concern to her family about a woman she described as a police officer who had confronted her on multiple occasions, allegedly appearing at her workplace and approaching her in ways that felt threatening and deeply unsettling. Sherry's parents have recalled that their daughter told them specifically she was afraid of this woman, that she felt the woman posed a genuine threat to her safety, and that the connection to John Rutten was at the heart of the woman's hostility. Sherry's concerns were not baseless, as the events of February 24, 1986 would prove. On that day, Sherry Rasmussen was found dead in the home she shared with John Rutten in the Van Nuys neighborhood of Los Angeles. She had been beaten severely, shot 3 times, and there were bite marks on her arm, injuries consistent with a violent and sustained physical struggle. Investigators at the time initially treated the case as a burglary gone wrong, a conclusion that Sherry's family disputed from the beginning, insisting that Sherry had told them she feared the police officer from Rutten's past and that this woman should be considered a suspect. The family's concerns were not adequately investigated. The case was assigned to detectives who pursued the burglary theory, and when that theory failed to produce a viable suspect, the investigation stalled. Sherry Rasmussen's murder went unsolved. The years passed. John Rutten remarried. Sherry's parents, Nels and Loretta Rasmussen, never stopped advocating for justice for their daughter, never stopped believing that the woman Sherry had feared was responsible, and never stopped pressing law enforcement to look more carefully at the person their daughter had named. It took 23 years. In 2009, a cold case detective reviewing the Rasmussen file made a decision that would ultimately crack the case open. The detective arranged for DNA testing of the biological material recovered from the bite mark on Sherry's arm, evidence that had been preserved in the case files for over 2 decades. When the results came back, they produced a profile that was entered into law enforcement DNA databases. The profile matched a woman named Stephanie Lazarus. By 2009, Lazarus was no longer a patrol officer. She had risen to the rank of detective and was working in the LAPD's art theft division. She had, in other words, spent 23 years not merely evading justice but building an entire career within the very institution whose cold case files contained the unsolved murder she had committed. The investigation that followed was conducted with extraordinary care and delicacy, because investigators understood that arresting an LAPD detective based on a DNA match from a decades-old case would require a flawless evidentiary foundation. Detectives conducted surveillance on Lazarus and arranged a covert operation in which she was approached at a shopping mall and offered a cup of coffee, from which they recovered a fresh DNA sample. The fresh sample matched the decades-old sample from the bite mark. The case was airtight. On June 5, 2009, Stephanie Lazarus was arrested while at work at LAPD headquarters. She was taken into custody in front of colleagues who had known her for years, officers who had no idea that the woman they worked alongside had committed a murder more than 2 decades earlier. The arrest sent shockwaves through the department and through the broader law enforcement community. Lazarus was charged with first-degree murder. Her trial, which began in 2012, centered on the DNA evidence and the circumstantial evidence linking her to the crime, including the bite mark, the history of her relationship with Rutten, and Sherry's documented fears about a female LAPD officer. Nels Rasmussen testified about the conversations he and his wife had with Sherry in the months before her death, the warnings Sherry had given that she was afraid of this woman. John Rutten testified as a prosecution witness, confirming the history of his prior relationship with Lazarus and the context that the prosecution argued had provided Lazarus with a motive rooted in jealousy and an inability to accept that Rutten had chosen another woman. Lazarus maintained her innocence throughout. The jury deliberated and returned a verdict of guilty on the charge of first-degree murder. Lazarus was sentenced to 27 years to life in state prison. The verdict brought a measure of closure to the Rasmussen family, who had waited over a quarter-century for justice for their daughter, but it also left profound questions about institutional failure in its wake. The LAPD had failed to seriously investigate the lead that Sherry herself had provided, the fear of a female officer with a connection to her husband, and in doing so had allowed a murderer to serve as a detective within its own ranks for over 2 decades. Had investigators in 1986 pursued the lead that Sherry's family gave them, the outcome of this case might have been entirely different. Instead, Sherry Rasmussen's killer spent 23 years earning a salary, a pension, and the professional respect of her colleagues, while the woman she murdered lay in her grave and her family waited for justice that was inexcusably, unconscionably delayed. Number 4. Kim Potter, the veteran officer and the taser that was never a taser. On the afternoon of April 11, 2021, in the city of Brooklyn Center, Minnesota, a 26-year veteran of the police force made a mistake that she would describe as the most catastrophic error of her professional life, and a 20-year-old young man named Daunte Wright would not survive it. The case of Kim Potter is, in many respects, one of the most debated in recent American law enforcement history, not because the facts themselves are unclear, but because the question of whether what happened was a genuine and tragic accident or something more culpable, something rooted in failures of training, professional judgment, and institutional culture, cuts to the heart of how American society evaluates police conduct and holds officers accountable for the deaths they cause. Daunte Demetrius Wright was 20 years old on the day he died. He was a young black man from the Minneapolis area, a father to a young son, someone who, by the accounts of his family, was navigating the ordinary complications of early adulthood with humor and love. On that April afternoon, he was pulled over by Brooklyn Center police officers who indicated that his car had expired registration tags and an air freshener hanging from the rearview mirror, a minor traffic violation. What should have been a routine traffic stop quickly took a different turn when a records check revealed that Wright had an outstanding warrant for a misdemeanor, related to a failure to appear in court on charges of carrying a pistol without a permit and fleeing from officers in a prior incident. When officers attempted to place Wright under arrest to take him in on the warrant, the situation escalated. Wright, who was standing outside his car, broke free from the officers attempting to detain him and got back behind the wheel. It was at this moment that Kim Potter, who was present at the stop and had been supervising a newer officer, drew what she believed was her taser, shouted, "Taser! Taser! Taser!" as officers are trained to announce when deploying a taser, and fired. What she actually fired was her department-issued Glock 9mm service pistol, the weapon she had carried for 26 years as a police officer. The weapon that is heavy and black and substantially different in weight, feel, and grip from the bright yellow taser she believed she was deploying. The single bullet struck Daunte right in the chest. He drove away from the scene, traveled a short distance, and crashed into another vehicle. He was pronounced dead at the scene. The moment was captured on body cam footage, which Brooklyn Center police released shortly afterward. The footage showed Potter drawing her weapon, shouting the taser warning, firing, and immediately recognizing her mistake. "I shot him," she can be heard saying on the recording, her voice carrying what seemed to be immediate horror and shock. The chief of the Brooklyn Center Police Department, Tim Gannon, described it publicly as an accidental discharge, a characterization that drew immediate and fierce criticism from civil rights advocates and the broader community, who argued that calling the killing of an unarmed young man an accidental discharge failed to grapple with the question of how a 26-year veteran of law enforcement could fail to distinguish between her service weapon and her taser. In the days following Wright's death, Brooklyn Center became the site of significant protests, coming as they did in the context of the ongoing trial of Derek Chauvin in Minneapolis for the murder of George Floyd, a trial that was at that moment entering its final stages just miles away. The convergence of these two cases, unfolding almost simultaneously, intensified the national reckoning over policing and racial justice that had defined the prior year. Kim Potter resigned from the Brooklyn Center Police Department 2 days after the shooting. She was subsequently charged with first-degree manslaughter, which requires proof that the defendant caused someone's death through a consciously unreasonable risk, and second-degree manslaughter, which requires proof of culpable negligence creating an unreasonable risk. The prosecution argued that Potter, as a 26-year veteran and a certified police trainer, bore a higher standard of professional responsibility than a newer officer, and that her failure to distinguish between two fundamentally different weapons represented not merely an accident but a criminally culpable failure of professional judgment. The defense argued that the circumstances of the incident, the chaos of an arrest situation with a resisting subject, the split-second nature of the decision, and the genuine shock and remorse Potter displayed immediately afterward supported the conclusion that this was a tragic mistake rather than a crime. Potter testified in her own defense, breaking down in tears on the witness stand and describing the moment she realized she had fired the wrong weapon. Her emotional testimony generated significant public discussion about whether such displays of remorse and distress are received differently when the defendant is a woman compared to male officers in similar circumstances. The jury, after deliberating, convicted Kim Potter on both counts of manslaughter. The conviction was significant because it represented a relatively rare instance of an on-duty officer being found criminally liable for a shooting that the officer herself described as unintentional. At sentencing, prosecutors sought 7 years. The judge, Regina Chu, sentenced Potter to 2 years in prison, with 16 months to be served before she was eligible for supervised release. The sentence was widely criticized by advocates for the Wright family and by those who argued that the disparity between the sentence sought and the sentence imposed reflected a persistent double standard in how courts treat law enforcement defendants. Potter was released in August 2022. Daunte Wright's family has continued to speak publicly about their loss and about the broader systemic issues his death represented, advocating for reforms to police training and accountability that they hope will prevent other families from experiencing what they have endured. Number 5. Betty Shelby, the officer who walked free after killing an unarmed man, then taught others how to do it. The killing of Terrence Crutcher by Tulsa Police Department officer Betty Shelby on September 16, 2016, and the legal and professional aftermath that followed represents one of the most troubling cases in the history of American law enforcement accountability, not only because of what happened on that street in Tulsa but because of what happened in the years that followed, when the officer who pulled the trigger was acquitted of all charges, resigned from one police department, and subsequently obtained employment with another law enforcement agency where she reportedly taught courses on use of force. It is a story that encapsulates, with brutal clarity, the systemic failures that have allowed officers who kill unarmed people to continue working in law enforcement with little to no professional consequence. Terrence Crutcher was 40 years old on the evening of September 16, 2016. He was a father and a student at Tulsa Community College, and by accounts from those who knew him, he was a man who had struggled with personal difficulties but who was working to build a better life. On that Friday evening, Crutcher's SUV was found stopped in the middle of North 36th Street in North Tulsa. Officers had responded to an unrelated call in the area and came upon the stopped vehicle. Betty Shelby was among the first to arrive. What unfolded over the next few minutes was captured from 2 angles: footage from a police helicopter circling overhead and footage from a patrol car dashcam. The footage shows Terrence Crutcher walking away from his vehicle toward the driver's side, moving slowly, with his hands visible and raised. Multiple officers can be seen following him. Then, as Crutcher reaches the driver's door of his SUV, standing next to it with his hands up or reaching for the car door depending on the interpretation of the footage, Betty Shelby fires a single shot from her service weapon. Simultaneously, another officer deploys a taser. Crutcher collapses to the ground. No weapon was found on Terrence Crutcher's person or in his vehicle. The SUV's window was rolled up. The key was in his pocket, not in the ignition. The narrative that he had reached through an open window toward something inside the car, which formed a component of the justification offered for the shooting, was contradicted by the physical evidence. He was unarmed. He was moving slowly. His hands were visible. And he died on that street while the officers who had surrounded him stood and watched. The helicopter footage, in which an officer in the aircraft can be heard referring to Crutcher as a bad dude, added a dimension of dehumanization to the case that intensified public scrutiny. Betty Shelby told investigators that she had feared for her life, that Crutcher had not complied with her commands, that his behavior suggested he might be under the influence of PCP, a drug that is associated in officer training materials with unpredictable and violent behavior, and that as he moved toward his car she had believed he was reaching for a weapon. PCP was later found in Crutcher's system, though the question of how that information should factor into the assessment of the shooting, given that it was not available to Shelby at the moment she pulled the trigger and given that Crutcher had not made any physically threatening move toward officers, remained deeply contested throughout the legal proceedings. Betty Shelby was charged with first-degree manslaughter. The charge acknowledged that the killing had occurred but framed the legal question around whether Shelby had acted recklessly or with gross negligence rather than whether she had intended to kill. The trial took place in May 2017 and drew national attention. Shelby's defense team presented the case as a tragic but legally justified response to a situation in which an officer, following her training, made a reasonable assessment of a perceived threat. The prosecution argued that the video evidence contradicted the narrative that Crutcher posed an imminent threat at the moment he was shot, that the physical evidence, in particular the rolled-up window, undermined the claim that he was reaching for a weapon inside the vehicle, and that a reasonable officer would not have fired. The jury, after deliberating, acquitted Betty Shelby on the manslaughter charge. The acquittal was met with protests in Tulsa and national expressions of outrage from civil rights organizations and community advocates, who argued that the verdict demonstrated that the American criminal justice system was structurally incapable of holding police officers accountable for the deaths of unarmed black men. Following the acquittal, Betty Shelby resigned from the Tulsa Police Department. She was subsequently hired as a deputy sheriff by the Rogers County Sheriff's Office in Oklahoma, where, according to reporting by various news organizations, she became involved in training other officers, including on topics related to use of force. The prospect of an officer who had shot and killed an unarmed man being placed in a position to train other officers in the use of deadly force was deeply troubling to the Crutcher family and to civil rights advocates, who argued that it sent a profoundly damaging message about the standards law enforcement institutions apply when assessing the fitness of officers involved in controversial shootings. The civil case brought by the Crutcher family was eventually settled, with the city of Tulsa paying a significant sum to the family. But for Terrence Crutcher's family, and for the broader community that watched his final moments in that helicopter footage, hands raised, walking slowly back toward his car, the legal and professional outcomes of the case left a wound that no civil settlement could fully close. The question of how a system can claim to value accountability when it acquits the officer who shot an unarmed man and then employs her as an instructor is one that the Crutcher case places before the public with no comfortable or easy answer. Number 6. Lisa Steed, the trooper who built a career on lies and destroyed innocent lives in the process. Not all police criminality involves violence. Some of the most devastating abuses of law enforcement authority are perpetrated without a single shot being fired, without any physical confrontation at all. And it is precisely the absence of physical violence that makes these cases so insidious, because they unfold slowly, systematically, and largely invisibly until the accumulated weight of the harm done finally collapses the carefully constructed fiction that sustained them. The case of former Utah Highway Patrol Trooper Lisa Steed is a searing example of this category of police misconduct, a case in which an officer fabricated evidence, lied in court and on official documents, and destroyed the reputations, finances, employment records, and peace of mind of dozens of people who had done nothing wrong, all while being celebrated by her department as one of its most productive and effective officers. Lisa Steed worked for the Utah Highway Patrol, a division of the Utah Department of Public Safety, and for a period in the late 2000s and early 2010s she was, by the statistical measures her department used to evaluate performance, an extraordinary officer. She made more DUI arrests than virtually any other trooper in the state. She was recognized for her work. She received commendations. She was held up within the department as a model of effective law enforcement. The problem was that a substantial number of the DUI arrests she was making were fraudulent. People who were completely sober when they were pulled over by Lisa Steed were being charged with driving under the influence based on her testimony that they had failed field sobriety tests, that they had exhibited signs of intoxication, that she had observed behaviors consistent with impairment. In case after case, these claims were simply not true. Drivers who had not consumed any alcohol or drugs were subjected to arrest, to the humiliation and terror of being handcuffed and placed in a patrol car, to booking and processing, to the publication of their names in DUI records, to the loss of their driver's licenses, to the financial devastation of legal fees and insurance rate increases, to the professional consequences of having a DUI on their record, and in some cases to job loss and the breakdown of personal relationships. All of this happened because a police officer decided to lie. The first cracks in Steed's record appeared when defense attorneys handling DUI cases she had generated began noticing inconsistencies. In court proceedings, some defendants had insisted they were completely sober at the time of their arrests, and when their blood tests came back negative or showed no impairment, the question of how an experienced trooper had concluded they were drunk became increasingly difficult to answer with any credible account that did not involve deliberate fabrication. As more cases were scrutinized, a pattern emerged. Attorneys and legal observers noted that Steed's arrest records showed remarkable consistency in the behavioral indicators she described in her reports, as if she were drawing from a template rather than documenting genuinely observed conduct. Dash camera footage from traffic stops, where it existed, sometimes failed to corroborate the descriptions in her reports. The Utah Department of Public Safety launched an internal investigation. What investigators found was deeply damning. The investigation determined that Steed had engaged in misconduct across a significant number of cases, falsifying field sobriety test results, making claims in her official reports about observations and driver behavior that were not supported by available evidence, and in doing so had obtained arrests that were built on lies. She was terminated from the Utah Highway Patrol. Criminal charges followed. Steed was charged with offenses including making a false written statement, a serious crime that strikes at the very foundation of the legal system's reliance on the truthfulness of law enforcement testimony. The legal proceedings against Steed resulted in a guilty plea, and she received a sentence that included probation. But the consequences for the individuals she had wrongly arrested proved far harder to remediate. The state of Utah undertook a review of the DUI cases Steed had made, a process that ultimately resulted in the dismissal of dozens of convictions and the expungement of records for individuals who had been carrying the stigma of a DUI conviction based entirely on Lisa Steed's dishonest testimony. For those individuals, many of whom had lost jobs, paid enormous legal fees, had their reputations damaged in their communities, or suffered the consequences of having a criminal record follow them through background checks and professional licensing processes, the dismissal of their charges brought a measure of vindication but could not undo the harm that had already been done. The Steed case raises profound questions about the systemic incentives within law enforcement that can inadvertently reward quantity over integrity, that can create environments in which an officer who makes a large number of arrests is celebrated and protected rather than scrutinized, and in which the complaints of defendants insisting they were sober are routinely dismissed as self-interested denials rather than potentially credible challenges to the accuracy of an officer's account. It is a case that speaks to the critical importance of robust dashcam and bodycam footage, of independent oversight, and of criminal justice systems that do not simply accept the word of a uniformed officer as automatically more reliable than the word of the person they arrest. For the dozens of people whose lives were upended by Lisa Steed's fabrications, the badge she wore was not a symbol of protection. It was a weapon she used to do them harm, one lie, one false report, one fabricated field sobriety test at a time. Number 7. Annie Ducon, the crime lab ghost who poisoned 40,000 cases. The criminal justice system depends on an intricate web of professional integrity to function. Judges rely on prosecutors, prosecutors rely on investigators, investigators rely on forensic scientists, and forensic scientists occupy a uniquely critical position in that chain, because their findings, presented in court as objective scientific truth, carry a weight of authority that is extraordinarily difficult for defendants or defense attorneys to challenge without access to independent testing and resources that many low-income defendants simply do not have. When a forensic scientist betrays the trust placed in them, the damage they can do extends far beyond any single case. It radiates outward through the entire network of prosecutions that relied on their work, calling into question the legitimacy of convictions, the accuracy of sentences, and the fundamental promise of the justice system that its outcomes are based on truth rather than fabrication. The case of Annie Ducon, a chemist who worked at the William A. Hinton State Laboratory Institute in Jamaica Plain, Massachusetts, the state's primary drug testing facility for the criminal justice system, is one of the most consequential examples of forensic fraud in American legal history, a case in which a single individual's sustained dishonesty compromised tens of thousands of criminal cases, resulted in the imprisonment of an unknown number of people on the basis of falsified evidence, and ultimately forced the Massachusetts Supreme Judicial Court to take the extraordinary step of presumptively dismissing over 21,000 drug convictions in cases connected to her work. Annie Ducon had been employed as a chemist at the Hinton Lab since 2003. By all outward appearances, she was an exceptional employee. She processed drug samples at a rate far exceeding that of her colleagues, and her productivity earned her recognition and professional admiration within the lab. In a system under pressure to process high volumes of evidence quickly in order to keep the courts functioning, an analyst who could handle that workload efficiently was immensely valuable. What no one initially suspected was that the reason Ducon was able to process so many samples so quickly was that she was not actually conducting the proper testing procedures on all of them. Investigators eventually determined that Ducon had engaged in a practice known in forensic circles as dry labbing, testing samples without following required procedures or, in some cases, simply not testing them at all and recording results she had fabricated. She forged the signatures of her colleagues on documents to make it appear that tests had been independently confirmed. She mixed samples together in ways that compromised their integrity and produced misleading results. She sometimes added actual drug material to samples that contained none, ensuring that a test would return a positive result for a controlled substance. And she did all of this, apparently, for years under the very noses of supervisors and colleagues who had no idea that the data flowing out of her workspace was systematically corrupted. The fraud was first discovered in 2011 when a colleague noticed a discrepancy related to sample access and raised concerns with supervisors. An internal investigation began, and as the scope of what Ducon had done slowly became clear, the state was confronted with the appalling realization that the evidence underpinning thousands of criminal prosecutions across Massachusetts was potentially worthless. The Massachusetts Department of Public Health suspended operations at the Hinton lab. The investigation expanded. State officials began the grim process of trying to assess how many cases might be affected and what could be done to address the harm that had been done. Annie Ducon was arrested in 2012 and charged with obstruction of justice, evidence tampering, and perjury. In November 2013, she pleaded guilty to 27 counts of these charges. She was sentenced to 3 to 5 years in state prison. She was released in 2016 after serving approximately 2.5 years. The legal aftermath of Ducon's fraud stretched for years after her release. Defense attorneys filed motions on behalf of thousands of clients whose convictions had rested on Ducon's analysis, and the courts were inundated with challenges. In 2017, the Massachusetts Supreme Judicial Court issued a landmark ruling that presumptively vacated over 21,000 convictions in cases where Ducon's work was the sole or primary evidence of the presence of a controlled substance. It was one of the largest mass dismissals of criminal convictions in American history, and it represented an extraordinary acknowledgement by the state's highest court that the justice system had failed those thousands of defendants, many of whom had served time in prison, paid fines, lost professional licenses, suffered the immigration consequences of drug convictions, had custody of their children affected, and carried the stigma of a criminal record, all on the basis of evidence that was never scientifically valid. The full human cost of Annie Ducon's fraud will likely never be fully quantified. The thousands of people who passed through the criminal justice system on the strength of her falsified results represent a vast, largely anonymous community of individuals whose lives were altered by a single person's decision to betray the professional responsibility placed in her. Many of those individuals were low-income people of color who had already been marginalized by the systems that were supposed to serve them, people who lacked the resources to mount robust legal challenges to the evidence against them, who accepted plea deals rather than risk trial, who did not have the knowledge or access to legal counsel to know that the science being used against them was fraudulent. Ducon's case is a profound indictment of the oversight failures that allowed her fraud to continue for nearly a decade, the pressures that were placed on forensic labs to process high volumes of evidence quickly without adequate quality control, and the broader systemic failure to take seriously the principle that every piece of evidence presented in a criminal prosecution must be genuinely reliable. The badge that law enforcement wears is not always a physical object. Sometimes it is the authority of a state laboratory credential, a professional title, a white coat that signals expertise and trustworthiness to judges, juries, and defendants who have no meaningful way to challenge it. When that form of authority is used as a weapon, the damage it causes is vast, quiet, and extraordinarily difficult to undo. Number 8. Carryall Horne, the officer who did the right thing and was punished for it, while her corrupt colleague walked free. There is a dimension of police criminality that rarely receives the attention it deserves in public discourse about law enforcement accountability, and it is this: the stories of the officers who witness misconduct, who try to stop it, who report it, and who are subsequently destroyed by the very institution they served, while the officer who committed the misconduct faces little or no meaningful consequence. The case of former Buffalo Police Department officer Carryall Horne is, in one sense, the story of a good officer, a woman who did exactly what we are told officers are supposed to do when they witness a colleague using excessive force, who intervened, who tried to protect a citizen from harm, and who lost her career, her pension, and nearly 2 decades of her life fighting to have the truth of what happened that day acknowledged by the city she served. But the case of Cariol Horn cannot be fully told without also telling the story of the officer she intervened against, Gregory Kwiatkowski, and the pattern of conduct that preceded the incident involving Horn, a pattern that reveals an officer whose history of violence and racial hostility was known within the department and tolerated until it became impossible to ignore. Understanding both stories together is essential to understanding how institutions protect their own, how the culture of silence within law enforcement agencies enables misconduct to continue and escalate, and how the officers most harmed by that culture are often those with the greatest integrity. Cariol Horn joined the Buffalo Police Department in 1995. She served for 13 years, working in a department that was, by multiple accounts, not without its institutional difficulties regarding racial equity and the treatment of officers of color. Horn is a black woman, and her experience within the department was shaped in part by the dynamics of race that have historically complicated the experiences of officers of color in predominantly white police institutions. On November 11, 2006, Horn responded to a call involving a domestic disturbance at a residence on Dote Street in Buffalo. When she arrived, she found fellow officer Gregory Kwiatkowski in the process of subduing a man named Neil Mack. Kwiatkowski had Mack in a chokehold. Mack was handcuffed. He was not actively resisting. He was restrained. And yet Kwiatkowski continued to apply the chokehold with a force that Horn assessed, in the moment, as a threat to Mack's life. She intervened. She physically intervened, grabbing Kwiatkowski's arm to break the hold and stop what she believed was potentially lethal force being applied to a man who was already subdued and in custody. It was exactly the kind of intervention that law enforcement ethics demand. An officer witnessing what she assessed to be a serious and ongoing abuse of force, using the minimum necessary physical intervention to stop it, and doing so in the service of protecting the person in custody. For this act, Cariol Horn was struck in the face by Kwiatkowski. She was subsequently charged by the department with conduct unbecoming an officer for her interference in a fellow officer's arrest. She was suspended without pay, and when the disciplinary process was complete, she was fired from the Buffalo Police Department just 1 year before she would have completed the 20 years of service required to vest her pension. The loss of her pension was not incidental. It was devastating. Horn had given 13 years of her life to the department, had raised her children in part on the salary it paid her, and had planned her financial future around the retirement security that pension represented. Its loss meant that the financial safety net she had worked to build was gone, taken from her as punishment for trying to prevent what she believed was a potentially deadly assault on a handcuffed man. Gregory Kwiatkowski, meanwhile, faced no immediate disciplinary consequence of significance for the conduct Horn had tried to stop. He continued to serve on the force. He continued to work as a police officer. His story did not end there, however, and the subsequent chapters of his career reveal the extent to which the department's protection of him in the aftermath of the Horn incident was an extension of a pattern of institutional tolerance for his behavior rather than a genuine assessment that he had done nothing wrong. In 2014, years after Horn had been fired, Kwiatkowski was indicted on federal civil rights charges. The charges arose from incidents that allegedly occurred after the 2006 chokehold incident, including allegations that he had used racially derogatory language and had directed or participated in physical assaults on individuals in custody. He pleaded guilty to federal civil rights violations and was sentenced to 4 months in federal prison. The conviction of the officer Horn had tried to stop on federal civil rights charges provided a measure of vindication for her account of his conduct, but it did not restore her pension or her career. Horn spent years fighting through the courts and through public advocacy to have the injustice done to her recognized and remedied. Her case became a touchstone in national conversations about the duty of officers to intervene against police misconduct and about the retaliation that officers who do intervene too often face. The concept of active bystander intervention in policing, the obligation of an officer who witnesses misconduct to take action to stop it rather than remaining passive or closing ranks, had been discussed in law enforcement training contexts for years, but the Horn case illustrated with painful clarity the institutional reality that officers who actually intervened in the way the training recommended could find themselves punished for doing so. In 2021, the city of Buffalo passed what became known as Carryall's Law, an ordinance specifically designed to protect officers who intervene to stop excessive force from departmental retaliation. The passage of the law was a significant symbolic and practical victory, representing the formal acknowledgement by the city that what had happened to Horn was wrong, and that the institution had a responsibility to protect officers who act with integrity. In June 2021, a New York State Supreme Court justice ruled that Horn's termination had been improper, ordering the city to restore her pension. The ruling, coming 15 years after the incident on Dote Street, was the culmination of a fight that had consumed a significant portion of Horn's adult life. She had not given up. She had continued to advocate, to speak, and to insist that the truth of what happened that day mattered. And eventually, after years of legal struggle and public advocacy, the truth was formally acknowledged. The case of Carryall Horn and Gregory Kwiatkowski together illuminate one of the most corrosive dynamics in law enforcement culture: the way institutions that claim to value integrity can simultaneously punish those who demonstrate it and protect those who violate it, the way the code of silence operates not merely as an informal social pressure but as a systemic mechanism that shapes careers, determines pensions, and decides whose account of events the institution is willing to believe. The badge in Kwiatkowski's hands was a license for violence. In Horn's hands, it was a target. Number 9, Numan Raja, and the department that knew, and the system that still took years to respond. Among the most unsettling truths about law enforcement misconduct is the degree to which it is sometimes not truly hidden, not buried in files that no one reads or concealed through sophisticated cover-ups, but visible, documented, complained about, and simply not acted upon by the institutions responsible for oversight and accountability. The killing of Corey Jones by Palm Beach Gardens Police Department officer Numan Raja on October 18, 2015, and the investigation that followed raised profound and deeply troubling questions about what it means when a police department places an officer on the street who has a documented history of complaints and concerning behaviors, and that officer then kills someone under circumstances that eventually result in a murder conviction, and whether the institutional failure that placed him there bears any share of moral and legal responsibility for what occurred. Numan Raja joined the Palm Beach Gardens Police Department in 2014, relatively new to the specific department but not to law enforcement. His record within the department was not without prior concerns. Colleagues had reportedly raised issues about his conduct and professional behavior, and at the time of the shooting that would end his law enforcement career and ultimately result in his imprisonment, an internal affairs investigation into his behavior was reportedly pending. That investigation had not been resolved. He remained on active duty. He was on the street. He was armed and in plain clothes, driving an unmarked white van, on the night he encountered Corey Jones. Corey Jones was 31 years old. He was a drummer who played with his church band, a deeply religious young man by the accounts of those who loved him, someone who found expression and community through music and whose family remembers him as a person of warmth, faith, and quiet dignity. On the early morning hours of October 18, 2015, Jones was stranded on an interstate off-ramp in Palm Beach Gardens. His car had broken down, and he had been waiting for a tow truck for hours. It was nearly 3 in the morning. He was alone on the side of the road, his disabled vehicle with its hazard lights on behind him, and he was on the phone with his uncle when an unmarked white van pulled up. The man who stepped out of that van was Numan Raja. He was not in a marked police vehicle. He was not in uniform. He was dressed in civilian clothes. From Corey Jones's perspective, an unmarked van had stopped at 3 in the morning on a dark roadway, and an unidentified man in civilian clothes was approaching him. There is evidence suggesting that Jones, who legally possessed a firearm and had a valid permit for it, may have drawn or produced the weapon in response to this encounter, a response that, from the perspective of a stranded motorist approached by an unidentified individual in the early morning hours, is not difficult to understand. Raja shot Corey Jones 3 times. Jones was found in the grass near the off-ramp. He was pronounced dead. Raja's account of the encounter was that he had identified himself as a police officer and that Jones had pointed a firearm at him. Subsequent investigation raised serious questions about the credibility of this account, including questions about Raja's approach to the scene, the absence of clear evidence that he had properly identified himself before the confrontation escalated, and inconsistencies in the account he provided to investigators. The investigation into the shooting was conducted by the Palm Beach County State Attorney's Office, and in April 2016, roughly 6 months after the shooting, Raja was charged with manslaughter and attempted manslaughter. As the investigation continued and the evidence was more fully developed, the charges were upgraded to first-degree murder in January 2017. The decision to charge a police officer with first-degree murder in connection with an on-duty shooting was significant and unusual, reflecting the prosecution's assessment that the evidence supported not merely a finding of recklessness or excessive force but of a criminal act meeting the legal standard for murder under Florida law. The trial took place in 2019, nearly 4 years after Corey Jones's death. The prosecution presented evidence challenging Raja's account of the encounter, including testimony and forensic analysis aimed at establishing the sequence of events and the physical positioning of the parties. The prosecution argued that Raja had not properly identified himself as a police officer, that the circumstances of the encounter, an unidentified man in civilian clothes approaching from an unmarked vehicle in the middle of the night, provided context for understanding Jones's response, and that Raja's use of deadly force was unjustified. The defense argued that Raja had identified himself, that Jones had pointed a weapon at him, and that the shooting was therefore a lawful act of self-defense by an officer responding to a perceived threat. The jury deliberated and returned a verdict of guilty on the charge of aggravated assault with a firearm as to one count and guilty of manslaughter with a firearm on another count. But the most significant outcome was the murder conviction, as Raja was found guilty of manslaughter and faced significant prison time. He was sentenced to 25 years in prison, later modified somewhat through the appellate process, but the conviction itself stood and represented one of the relatively few cases in which a Florida law enforcement officer was convicted of killing an unarmed civilian in circumstances arising from an on-duty encounter. The case of Newman Raja and the death of Corey Jones left the Jones family with a conviction but without the son, brother, and church musician they had lost on that roadside in 2015. It left the Palm Beach Gardens Police Department and the broader law enforcement community with questions about officer screening, about the internal affairs processes that had been pending when Raja remained on active duty, about what responsibility institutions bear when they retain and deploy officers whose conduct has drawn documented concerns. And it left the broader public with the recurring, agonizing question of how many similar encounters unfold on the roadways and in the communities of this country in circumstances that are never filmed, never fully investigated, and never result in any form of official accountability at all. The Jones family has continued to advocate for reforms in police oversight and accountability, carrying Corey's name forward in a campaign for systemic change that honors his life by trying to ensure that the failures that cost him it are not allowed to repeat themselves in the lives of others. Number 10. Crystal Theobald, the corruption ring that wore badges and ran like a cartel. The most systemic and institutionally devastating form of law enforcement corruption is not the individual officer who steals from a crime scene or the lone detective who fabricates evidence in a single case. Those betrayals, serious as they are, remain contained by their individual nature. The form of police criminality that poses the greatest structural threat to the communities it targets is the organized corruption ring, the group of officers who operate as a coordinated criminal enterprise, who use the collective power of their badges, their access to law enforcement databases, their knowledge of investigative procedures, and their shared code of silence to conduct criminal operations that can rival in sophistication and destructiveness the very organized criminal enterprises they are nominally employed to combat. The case that unfolded around the Rampart Division of the Los Angeles Police Department in the late 1990s and early 2000s, which became known as the Rampart Scandal, is one of the most studied examples of organized police corruption in American history. But the LAPD scandals, as devastating as they were, are not unique. Across American law enforcement history, there are cases in which groups of officers formed criminal enterprises inside their own departments, and the case of officers connected to the Ville Platte Police Department in Louisiana and broader documented patterns of corruption in small-town law enforcement represents a troubling template that recurs with painful frequency in communities that lack the institutional resources, the independent oversight mechanisms, and the political will to confront. However, among the individual stories that emerge from the broader landscape of organized police corruption, few are as personally devastating in their human particulars as the case connected to Crystal Theobald, a young woman in Jurupa Valley, California, whose murder in February 2006 unraveled over time into a story that intersected with allegations of gang affiliation, vigilante justice, and the deeply troubling question of what happens when the people tasked with solving a crime may have connections to those responsible for committing it. Crystal Theobald was 24 years old when she was killed in a drive-by shooting on February 23, 2006. She was in a car with members of her family, including her mother, Belinda Lane, and her brother, when another vehicle pulled up and opened fire. Crystal was struck and killed. The shooting appeared to be gang-related, occurring in a community where gang activity had created an environment of violence that touched the lives of families across the area. What followed was an investigation that took years, consumed an enormous amount of law enforcement resources, and brought to light a story that went far beyond an ordinary gang shooting into territory that raised profoundly disturbing questions about vigilante justice and the complicity of those who might look the other way or actively enable it. The investigation into Crystal Theobald's murder eventually identified members of the Rivera Street Gang as responsible for the shooting. Arrests were made, charges were filed, and prosecutions moved forward. But the larger story of what had motivated the shooting, what web of retaliation and violence had produced it, and what role various actors inside and outside law enforcement had played in enabling the environment in which it occurred continued to develop through law enforcement investigations and journalism for years afterward. The broader context of the Theobald case exists within a pattern that has been documented repeatedly in communities across the country, where the intersection of gang culture, law enforcement corruption, and the absence of effective independent oversight creates conditions in which violence can be both committed and enabled by those wearing badges. The Riverside County area had seen multiple instances of officers and former officers with documented connections to gang culture, and the investigation into the murder brought these intersections into sharp relief. Belinda Lane, Crystal's mother, became one of the most determined and publicly visible advocates for justice in her daughter's case, working for years to ensure that all those responsible were identified and held accountable. Her persistence in the face of institutional indifference and the labyrinthine complexity of a case that involved multiple actors across multiple jurisdictions stands as a testament to the kind of advocacy that families of victims are sometimes forced to undertake when they cannot trust that the justice system will pursue the truth on their behalf with sufficient determination and integrity. The prosecutions that ultimately resulted from the investigation into Crystal Theobald's murder involved multiple defendants and produced convictions that brought some measure of accountability to those directly responsible for the shooting. But for Belinda Lane, the journey to those convictions was one defined by years of frustration, repeated encounters with institutional resistance, and the gnawing awareness that her daughter's death had occurred in a community where the boundaries between law enforcement and criminality had become perilously blurred. The Theobald case, viewed in its full context, is a story about the catastrophic consequences that flow from the failure of law enforcement institutions to police themselves, from the absence of meaningful external oversight, from the culture of silence that protects corrupt officers from accountability, and from the devastating human cost that falls on ordinary families who find themselves trapped in the space between a criminal world that threatens them and a law enforcement world that cannot always be trusted to protect them. Crystal Theobald deserved to live. She deserved to grow old in a community where the badge meant what it was supposed to mean. And the fact that she did not, the fact that her mother spent years fighting through an impenetrable tangle of institutional failures and deliberate obstructions to obtain anything approaching justice, is a story that speaks not only to her individual tragedy but to the systemic failures that continue to make such tragedies possible, and in some communities, disturbingly likely. The badge is among the most powerful symbols in American civic life. When it is worn by someone who understands and honors the weight of what it represents, it genuinely can be a force for safety, justice, and community. When it is misused, when it is worn as cover for corruption, violence, or deception, the harm it enables is magnified by the very authority it represents. These 10 cases, taken together, represent a call to accountability, to reform, to the relentless insistence that trust must be earned and maintained through integrity, and to the memory of every person who was harmed because someone with a badge decided to use it as a weapon.